So a couple things I wanted to talk about just at the outset. I saw the folks in the participants. I know that many of you have attended some of these programs before. And I always say at the very beginning of our series, this is an Emerging Special Ed Leaders Academy. That's what ESELA stands for, Emerging Special Ed Leaders Academy. And the intention of this, when it was created a long time ago, was to help with a pipeline effort to have folks enter into leadership roles in special education. But what we have found is that those who've been in leadership roles for a while still enjoy coming and still enjoy doing a deep dive into these session topics. And so we've been doing that for, like I said, many years. And so number one, we're grateful that people are returning, but I also want to manage expectations for those who are returning. So up until this year, we did a deep dive, one topic per session. And based on feedback, we have this year consolidated some of the topics. So last year we did an entire 2.5 hours on child find and eligibility, and then a separate session on IEPs. Today's going to be both of those topics compressed. We know that those in these in positions, in leadership positions, and those who want to be in leadership positions, go through a lot of training, both training through the SST, information from ODE, things like that. So because we've compressed these two sessions, we're not going to do as deep of a dive, but instead, my intention is to just highlight those things where I think there's a need for a lot of focus at the leadership level. But that doesn't mean if I haven't covered a topic that you shouldn't pop a question in the chat or ask something that is, or raise a point that is meaningful to you, because we want to make sure that these sessions relate to the things that are top of mind for all of those of you who've decided to join us today. So with that in mind, let's go over a couple excuse me, a couple of disclaimers. Well, first of all, let me tell you, my name's Laura. I have been with Bricker Graydon for almost 27, 28-ish years. All of that time, I have been representing exclusively school districts and education institutions. I am the child of a parent of a disability. I am the parent of a child with a disability. But my bias and my background and what I do every day is to represent schools. You may hear that come out in some of my commentary, but I just give you that disclaimer. I also am the chair of the education group, and I lead a team that was about 30 people who represent institutions, both K-12 and higher ed, both inside Ohio and beyond. So that's the background that I come to these sessions with. But I also say that I have the privilege of working with people who have dedicated their careers to serving students with disabilities. And that is a tremendously gratifying way to use my legal degree. But so the things that I'm going to talk about are based on that experience and based working on people who are in leadership roles in special education. So that's one disclaimer. Number two is I am not providing legal advice today. I looked at the list of the folks who are joining us, and I know that I work with many of you, but I'm not going to be giving legal advice in this session. Number one, can't do that. Number two, not appropriate for me to do that, and it's would be a disservice to you without getting full information. So I'm not providing legal advice. And then the third disclaimer is that you should have access to a very comprehensive outline that has all of the information in it, but I can't cover everything with eligibility in a single hour. So I'm going to go through some highlights of eligibility and child find in the first hour. And then my colleague, Erin Heydrich, who practices in our Southwest Ohio area, and she's going to join us for a discussion about IEPs. I'm going to pass the baton over to her. So if you do have a question about eligibility or child find, let's make sure you get it in before I head off. I've got a hearing at just a little bit after 10, and so I won't be available after that for questions. So that is the introductory comments that I wanted to start with. And then I'm going to rely on the folks from the SST to let me know if there is a question in the chat, because I know there's a lot of back and forth about handouts and materials and things like that. So if there's something that I need to attend to, great, because I have they're going to let me know. So don't hesitate if you see a question pop up and I don't see it immediately. It's just because I have multiple screens going and I can't see them all. Okay, child find. Let's start there. Child find is the process, and I think we're on our next slide. Child find is our process of looking for those kids who might need special education. Where are they? Are they sitting in a seat in your district? Are they sitting in a seat in a non-public school that is located with your district? Are they not coming to school? Are they hospitalized? Are they having some sort of truancy issue? You know, what is happening with them? And the obligation on the part of the school district is affirmative, meaning you actually have to go and find those kids. Are they in the basement just gaming all day and all night and not coming to school? Like what is going on? And the affirmative duty includes a system of child find, meaning putting out notices, going through referrals, identification process, which is your evaluation, all of that stuff, and to determine who that you're responsible for evaluating and identifying requires special education. You cannot rely on parents to make those referrals. You have to maintain a system of notices and outreach efforts and training and referral procedures to get those students to you. Okay, our next, so that is child find, affirmative duty. So the other duty that you have, if you are the district of residence, is to make sure that you are providing interventions to address non-performance. So preschool or school-age students, you know that you have that requirement. And for those, and when we get into eligibility, we're going to talk about the relationship between this duty for interventions and special education, because it is only the students who, because of a disability and require not regular ed intervention, but they require special education, those are the students who are eligible for services. And it is helpful when we get into that conversation about are they eligible to have had some data as to whether or not they responded well to regular ed interventions. Okay, so that's the kind of the road to eligibility, and one of the requirements along that road is to be thinking about how do you provide supports that are not specialized instruction. Special education, that term is defined as an adaptation in the content, methodology, or delivery of instruction. So what I'm talking about here in terms of requirement to provide interventions, that's not that. It's not an adapted curriculum. It's not an adapted methodology. There's no adaptation of those things. This is just kind of differentiated instruction. And so once you get to the question of do they require an adaptation in the content, methodology, or delivery of instruction, it's great to have data that, oh no, they don't need a different curriculum because we were able to do these types of interventions that are not special ed. And so therefore it makes our eligibility determination easier. So we'll put a pin in that. I will talk about that more as we get into the eligibility standards. Excuse me. So we'll move on to our next slide. Excuse me. So when you think about the duties, the duties of child find include looking for those students who are attending non-public schools within your school district. So you're going to be looking for those kids who are sitting in a seat in a potentially a private school. And so your system of outreach has to include those non-publics. In addition, you're going to have child find obligations regarding your students, your district resident students who may be seeking or already on as part of the scholarship programs that exist. So know that there's related child find duties for non-pubs and for scholarship students. We'll move to the next slide and I'll get myself a drink. So I mentioned this already, that we cannot rely on parents to refer students. You have to think about the referral process in the sense that it is, number one, on us, on schools to make those referrals. But then when you do get a referral, you have to think about your applicable timeline. You can't just, and this is a thing that you need to train your folks, so you can't just sit on a referral. If a parent asks for, makes a referral, let's say during a parent-teacher conference, your teachers, those who interface with parents, have to understand what is the impact of somebody sending an email that says, I think my child might need special ed, or I think my child might need more support, or I think my child needs to have an evaluation. If that happens in an email or in some other format, a parent-teacher conference, something in passing, that was a referral. And the school has to respond to that. But the school can't respond to it if that referral just lands in the ear or in the inbox of somebody and they don't do anything about it. So one homework assignment for you is that if you are in a leadership position, make sure that the folks on your team, teachers, related service providers, whoever, other building administrators, counselors, they know that there's an affirmative duty on the district to also respond to a referral that is made. And we're going to move to the next slide. Why am I hammering on child fine? Because child fine violations are really expensive. They're expensive because, the reason that I and all of my colleagues have a job is because there's disputes in special ed and other areas of education. So, if people didn't disagree about what was appropriate and necessary, we wouldn't have a job. When there is a disagreement about special education, usually the disagreement is school district wants to provide this program and I want this program or some variation of that. And so there's a evaluation, or maybe litigation regarding, is this one appropriate or is this one appropriate? So you're comparing or you're looking at two options, what the parent wants and what the school wants. The reason that child fine violations are so significant, and the reason why that they're so difficult for districts, is that if you failed to meet your child fine obligation, meaning if you failed to affirmatively go out there and find those kids and evaluate them and propose and all of those things, there's nothing on this side, okay, that goes away. So you don't have any ability to do, okay, this versus this. The district has nothing to prove or to put on the table for a hearing officer to consider. And often by the time that the student is in some sort of litigation, what the parent is wanting and what the parent is seeking from the school district is a very expensive program. So let's say a kid is not coming to school, they're having some sort of emotional issues or school avoidance or, medical issues. And the district's like, yeah, well, when they come to school, they do okay. But whatever's happening outside of school, the district doesn't sense a need to engage in child fine. And so maybe the school avoidance compounds and is reinforced by the time at home, and the parent can't only get the child out of the house to go to school, but maybe they're not getting them out of the house at all, or maybe not out of their room, or maybe not out of their closet. Like there's a escalation of that need. And by that time, now we've got other folks involved, and we're, getting that kid out in the middle of the night and sending them to a residential treatment facility, right? And so then the parent can't pay for that, and they come to you and say, I would like you to pay for this residential treatment facility for my student who's got this significant mental health needs. And the district is not going to be in a position, if it didn't do any child fine, to say, child doesn't need residential treatment, here's our program. So know that those child fine violations really impact defense, and that's what I do. So that's why I'm raising it here. All right, we're going to move on. So our referral timeline starts with a referral, and there's that timeline I mentioned earlier, is that you have to do something within 30 calendar days. Those the two things that you have to do is either get consent, move it forward, get consent to evaluate, or issue prior written notice that you are not going to evaluate. You don't suspect a disability. Now, we are going to have a full session, not a compressed one, on discipline. And what I like to talk about during this session is the relationship between a referral and discipline, and those discipline protections that we will address, I think, during our third session. So know that if, under on the slide, you know that you have the option of saying, we're not going to evaluate, but you've got to do that within 30 days. You've got to issue prior written notice to say, we don't suspect a disability, we're not going to evaluate. So the law allows for that response, but just know that when you give that response, we are not going to evaluate. If later on that year, 5 years later, whenever, later on, if the student is subject to discipline, that student is considered to be a suspected disabled child because you did not close the door to eligibility. You did not conduct an evaluation or seek consent to conduct an evaluation and have that consent withheld. So just know that you create some exposure on discipline when you decide not to evaluate. We will talk about that a lot during the discipline section. I mention it here because I want you to be alert to that potential when there is no evaluation. Okay, let's move on to the next. So also know that we talked about those interventions, and that's great, but you cannot use your utilization of interventions as a way to shift the timeline or delay or say we're not going to evaluate. So you can't say, hey, we're going to do interventions, so therefore we're not going to move this evaluation forward. Okay. Instead, my suggestion to you is do the interventions while you're collecting data, while you're conducting your evaluation. If you have a 60 calendar day timeline from consent to do the evaluation, those 60 days would be a great time to try some interventions, because at the end of those 60 days, you can use that data to determine, did the student respond to regular ed interventions? That's going to be a real relevant point to the eligibility discussion that we're going to talk about in a bit. All right, next slide. Consent, know that one of the reasons, and we will have a whole session, we'll have a session on procedural safeguards. Know that consent is required for an evaluation, that consent has to be in writing. It has to be informed, meaning that the parent is informed of all of the things that you're planning on doing, and the parent has to understand that they can revoke that consent at any time. Our next slide. What happens if the parent says, I'm not going to give consent? So a couple things. If you know, like you know it, that the parent is not going to give consent, that doesn't mean you shouldn't ask for it in a formal way in writing and have them decline it in writing. Why is that important? Because number one, it establishes that you've tried, that you've complied with your duty to try to obtain informed consent within 30 days. You have a paper trail of that, and that you have a paper trail that the parent declined to provide consent. And remember when I talked to you that the door continues to be open if you decide not to evaluate? Well, the door will close if you ask for consent and it is declined. Okay, so get that in writing. That way the door for discipline protection isn't open. You can't say that a kid is suspected disabled and entitled to all of the discipline protections when they never allowed an evaluation of their eligibility, of their disability status. Okay. If you get somebody who says, I'm not going to allow you to conduct an evaluation, get that paper trail in writing. Also know that you can, if you want, file a due process action. You can seek an order from a court or a hearing officer to, through either, you can go to mediation, you can go to a due process hearing. So know that that's an option for you. And sometimes districts strategically think that's a good idea. However, know that although you can try to force an evaluation through due process, if you find that the student is eligible and the parent is still like, heck no, I'm not going to, engage in this process, you cannot force special education services on students through a due process hearing. But I do think that if the parent won't consent, you do your darndest to make sure that all of that is documented. And maybe the parent won't consent because of X, and that X is something you can address. So just make sure you continue to have that paper trail. All right. I am not going to go through all of the paperwork, but know that there are certain things that are required. These are required forms for your evaluation process. The ones listed on the screen are team reports, our prior written notice, the guide, consent forms, and your invitation. So those things, just as a checklist, maybe you have in your toolbox, were all those important evaluation paperwork, was that all completed as you're getting into your evaluation process? We'll move on. Who decides eligibility? Who is part of this process? Well, that team is legally prescribed. It's going to include parent, at least one regular education teacher of the child, at least one special ed teacher, provider of the child. And you may be thinking, well, we don't even know. We don't have a special ed teacher or provider of the child. Think about it. If the student was deemed eligible, who might they be connected to? Somebody who is the district rep. Now, I know for some districts, districts have used school psychologists as the district rep. Just know that the definition of district rep is somebody who is, and this is a legally required definition, somebody who is qualified to provide or supervise the provision of special education services. So that is one. So they either have to be able to deliver them or to supervise them. And then that the individual has to have knowledge about the available resources of the district and the ability to commit those resources in the district. So they have to be able to say, yes, this can happen, or no, this cannot happen. And then somebody who can interpret the instructional implications of evaluation results. Others who have specialized knowledge or expertise about the child. Maybe the parent thinks, Aunt Susie has special knowledge or expertise and they want to bring, that's fine. And then if the student, if it's appropriate to have the student, then that would be another person on the team. So make sure if you're doing this process, you're looking to the left and you're looking to the right, do we have a full team there? Because that would be a procedural requirement. Moving on. Where is our evaluation timeline? I already mentioned this, 60 calendar days. That is not 60 school days. That is not 60 days that we have contracted with a private psych. It is 60 calendar days. So if you get a request, if you get a referral and you get consent on June 1st, you're going to have to be making arrangements for that evaluation to proceed over the summer. And the evaluation can't be based on a single source, just looking at a particular, let's say it's a student with a articulation issue or some speech issue, and you only administer one assessment, and then you say, yep, we're done. You can't have a single source to determine eligibility, including the parent getting a doctor's note that says student is eligible for special education. Just because they have something written on a doctor's note doesn't, and you can refer to this to say there's no single source of information that serves as the sole criterion for determining eligibility. And so thank you for sharing this doctor's note, but it is not going to be the determining document or consideration for our team. Moving on. So here's our questions. Evaluation is looking at two things. Is the student a child with a disability? And we're going to get into that conversation. And then if the answer to that is yes, then the evaluation seeks to determine the needs of the student. So we're going to get into deeply, how do you make that call as to whether or not a child is a student with a disability, meets that legal definition of a child with a disability? I think that might be what's next. So as you go into that process, you are looking at a very large scope, all suspected areas of disability. So even if you're looking at an articulation issue, the student might have needs related to social emotional status because they can't communicate effectively with peers, or people don't understand them, they're not intelligible. And so they also might have behavioral issues, or they might have issues and needs for assistive technology, or they might have issues related to emotional issues. So make sure that as you're looking at your evaluation scope, you're being very comprehensive. If the doctor does write a note that says the student is eligible, the first thing that you should do is, say thank you for sharing that, and then ask for consent to consult with the doctor so that you can better understand the doctor's recommendations. Now, I don't know if I have it here. Yes, I do. Do I have? Yes. So this is the and I've used this resource before. This is the, can you see it? It's shiny. The Diagnostic and Statistical Manual of Mental Health Disorders. This is a kind of very interesting book. And yes, I have read it, and I'm, diagnose myself all the time. But what I also do is I look at it in the context of special education eligibility. And primarily because when doctors they make conclusions about a student's eligibility based on a medical diagnosis, sometimes, just saying, it's fun to look at the medical diagnosis, because for things like, a disability in the area of reading or things like that, in order to qualify for a medical diagnosis, there had to have been a lot of different assessments that were done, a review of the student's portfolio of work, a whole bunch of things that are required to get that diagnosis. So sometimes it's interesting, say sometimes fun, when you ask for that consultation to say, well, I noticed that this diagnosis requires X, Y, and Z. What information, what school-related information did you have for that diagnosis to be issued? Did you review the portfolio of the student's work and all of the things that are required? So just as an aside, consult with those medical providers. If the parent says, no, I'm not going to allow that consultation from the medical provider, make sure you just document that so that you can show that there was a request and there was a denial. Okay. All right, moving on. So I'm going to just skip over this. You know that we have our evaluation team report, and this is some documentation that you can use to identify what you have as existing data and what data needs to happen. You know that the evaluation is required at least once every 3 years unless there's a waiver, and no more than once a year unless the parents and the district agree. Next slide. We talked about consent. Okay. If the parent doesn't give consent, could you do a record review on a reevaluation? You can. If the consent is refused, you can decide that maybe you don't need to do an evaluation. And then, as I mentioned earlier, you can go forward and request due process or decide not to. So you have some options if consent is not provided. Moving on. If you decide that no further assessment is needed, just, think about that before you say we're not going to do an evaluation or we're only going to do a record review. From the perspective of somebody who defends school districts, a record review is hard to defend. I'm just putting it out there. Why? Because students' needs change over time. And in some situations, it's perfectly appropriate. But in many situations, remember I told you that the evaluation is to determine 2 things. Number 1, eligibility for special education services. And number 2, the educational needs of the child. So if you have done a record review in 2 consecutive evaluation periods and you have not had anybody assess that student for 6 years, that student you may not have current data upon which to make a determination about the student's eligibility for services and their educational needs. So you can say that you don't have a need for assessments, but you just be careful about that. Next slide. All right, so this is a stool. If you can't tell, that is the intention for this graphic, okay? And what I'm going to talk about for the remainder of our session together is eligibility from the context of the 3-legged stool, okay? And the reason that we use this analogy is because I want you to have a visual to understand that each leg of the stool, each part of this eligibility framework is equally important. It's because, let's say you're sitting on this stool and you're only emphasizing one, area of eligibility. What is going to happen? You are going to fall on your behind. Okay. And so my hope for you is that when you think about eligibility determinations, that you think about them from this framework of, I need to have information for each area. It's just critically important that you set that standard for your teams, because a couple of things sometimes happen and they throw the stool off balance. So one one thing that typically gets thrown off balance is the idea about a disabling condition. And so if you emphasize a disabling condition to the exclusion of the others, that is not making a really a eligibility determination based on criteria. And that often comes up, as I just mentioned, in the context of getting information from healthcare providers, because it is not just that an individual has a disabling condition, it is that the individual is educationally disabled. So it's not that they just have a diagnosis in this book, right? It is that they are educationally disabled. They have an educational disability, and that requires special education. So think about it differently. Both disability and diagnosis start with the same word. They are very different. And the healthcare provider can make a diagnosis, but they cannot determine eligibility under special education, okay? And districts feel like they get caught in the middle of this, right? And so getting these issues right is critically important because it's fundamental to the entire IEP process. It's getting the eligibility determination correct sets the stage for everything else. So districts sometimes feel caught in the middle between families who believe that they need special education in order to receive appropriate service. And they might feel caught in the middle of educators in general ed who think, you know, they're resisting to doing anything differentiated, and they believe that in order for a child to get something different, that they have to have a disability attached to them. And then sometimes administrators are just like, listen, it's easier for me to just agree to this and identify a student, and so I'm not in conflict with the parent. Okay, those are all competing factors. And the state and the US Department of Education comes down on districts to say, you are over-identifying students in particular categories. And so you've got all of these competing demands. So in order to navigate all of those demands, you have to understand the fundamentals of the eligibility process. And these fundamentals require you to have 3 elements of eligibility. Now, the elements are a disabling condition, an adverse effect on educational performance, and a need for specialized instruction. Okay, that seems kind of easy. It's not. Okay, so and the reason that the courts and hearing officers and lawyers get involved is that people disagree on the disabling condition. What effect, how much of an effect is adverse? What is educational performance? Is it solely academic? Is it more than that? What constitutes a need for special education? Do I actually have a need for it, or is it just nice to have? I mean, it would be nice, and my colleague Maya can attest to this. It would be nice if I had an aide, you know, walking around making sure I'm doing the right thing and have everything where I don't, you know, but that would be nice because I can be forgetful or scattered or, you know, many other things. But you know, having a one-on-one aide to take me to the groceries and make sure I remember to get the milk and all of the things, you know, that would be nice, but do I need it? And so just like disability and diagnosis are 2 things that start with the same letter. Need and nice start with the same letter, but the school district is required to look at educational need, not something that would be helpful or beneficial. It is actually a necessity, and that's the requirement. So these are the things that we're going to talk about in depth for the remainder of our time. Let's start with disabling condition. So a disabling condition includes somebody meeting the criteria on one of those areas. So disabling condition is, you know, specific learning disability, you know, other health impaired. So we're looking at the disabling condition meets one of these categories, and each of those categories has criteria. So they have to meet the criteria, and typically they then, because of that disabling condition, they require special education and related services. It's not enough to just have the condition. They also have to have that adverse effect and ultimately the need for special education services. Okay. So here are all of the eligibility categories. including, the extension of developmental delays for children aged 3 to 9. So these are, when you're making the determination about eligibility, you're looking at these criteria. Other health impairment is pretty expansive, and it includes a lot of things related to different health conditions, different attention conditions, things like that. Note that you're not going to see something like a diagnosis like dyslexia, dysgraphia, things like that. You're not going to see that. You're going to see things that relate to something that's a specific learning disability. So when you have people that say, I want my child to be identified as having dyslexia, that is not an eligibility category under the operating standards or the IDEA. All right, we're going to move on to the next. So that's that list that was on the screen. That's an exhaustive list. Now, if you think you need a medical diagnosis to move things forward and have an eligibility determination, know that that is a team decision. The team can ask for a medical diagnosis, but just know that if this parent is entitled to an evaluation at no cost. And so if you're asking the parent to go obtain a medical diagnosis before you do anything, it is the obligation of the school to provide and pay for that medical evaluation and diagnosis. So consider, do you really need a medical diagnosis to establish any of the areas? Or can you look at, let's say it's something related to a student's attention or concentration, can you do your own series of assessments to determine if they have an adverse effect on concentration such that they require specialized instruction? So know that the disabling condition is under one of those categories that I mentioned, that you don't need a medical diagnosis. And even if you have a medical diagnosis, the diagnosis might say that you are at risk for certain impacts, like, a student, as the demands increase, the student is at risk of falling behind. That is not eligibility. That is, they might become eligible in the future, but you're looking at eligibility from what is currently impact, because remember, those other legs of the three-legged stool is disabling condition, and then you're looking at adverse effect right now. Okay, moving on. Okay, so we talked about disabling condition. I've given you the what to do when you have a diagnosis. And the next thing that I want to talk about is, how do we determine that educational impact? Okay, so if you think about academic performance, you're looking at things that you can measure, grades and test scores and things like that. But that's not the end all be all. Educational performance, when you're looking at, does somebody have an adverse effect in their educational performance, you are looking beyond their grades. You are looking at beyond their iReady scores. You are looking at all of the things that make up their ability to perform educationally. How do they relate to peers? How are they with coming to school and attending to instruction? How are they with being given directions by their teachers? So you're looking at their communication ability, their ability to attend, their social emotional needs. And so many districts sometimes get caught up on focusing solely on academic performance when they're looking at the impact, whether it's adverse or not. The other thing that is important to think about is, what is adverse? Is it just any little impact, or does it have to be substantial? And that is the subject of many, many cases that on eligibility, where the theory could be, well, my kid is so gifted, has so much potential, has so much ability, and yet they're not living up to the potential. Even though they're getting all Bs in school and they're scoring at this level on the PSAT or other standardized assessments, they could be doing so much better. And so there's often this relationship between ability and performance where there's some litigation and disputes. So just know that that's a reason why there isn't a bright line test as to, how far do you have to fall below in order to show an adverse effect. And that's why I can't give you legal advice, because there isn't a bright line test. It is going to depend a lot on multiple factors. So let's just take, when you think about adverse effect, let's take one idea about when you go through your eligibility criteria, and let's just think about an autism eligibility. So the first thing you're going to do is to say, is the student diagnosed with autism? And then you're going to say, do you have that meet the criteria of a student with autism? So they have a developmental disability that significantly affects verbal and nonverbal communication and social communication. And then it comes into that adversely affects the child's educational performance. So you might have a diagnosis of autism. You might have an impact of verbal or nonverbal communication, but you might not have an adverse effect on educational performance. And then you also would have to rule out, autism doesn't apply if the child's educational performance is adversely affected primarily because the child has an emotional disturbance. And even the emotional disturbance criteria has a rule out. So you have to kind of go through, and my suggestion to you is when you're getting into eligibility conversations, you actually have the eligibility criteria out there, and so that you can tick through and look at each element of the criteria so that you can make a decision. All right, our next page. So when we think about educational performance, and I said this is going to be broader than just academics, we know that to be true because the entire purpose of the IDEA is beyond academics. It's not just about getting good grades. The purpose of the IDEA is to prepare students for further education, employment, and independent living. And that is beyond further education, employment, and independent living is beyond just getting good grades. It's, can you show up to work on time? Can you receive feedback from, your boss? Can you pivot when there's something unexpected that happens in the work setting? All of those, can you live independently? And so that's why educational performance is viewed much more broadly than just academics. All right. So when we think about, and this is just another example of why it's beyond academics, because you know that your goals when you're writing IEPs have to address both academics and functional goals. And so your goals have to, meet the child's educational needs and enable them to progress in the general ed curriculum. So all of those indicators mean that we're not just focused on academics when we're making eligibility determinations and we're deciding whether or not there's an adverse effect. All right, we're moving to the next slide. All right, so this is the other thing that I mentioned earlier. How bad does it have to get? Okay, is adverse effect a significant limitation, a significant adverse effect, or is any slight negative limitation qualify? And again, should the district consider the child's eligibility level? And then maybe you're thinking, well, there isn't an adverse effect because we're actually giving the student extended time and we're reducing homework. And so, nothing's going to show up on paper because they're able to manage with these kind of supports. We're excusing things that weren't turned in, whatever it is. And I will tell you that, you have a pretty comprehensive outline, and there are cases that are all over the place on this. My own personal opinion, and this is just the world according to Laura, my own personal opinion is it's not any old tiny limitation, that there has to be some substance to that limitation. The problem with that is, how do you measure that? And the other problem with that is not everybody listens to me. And, including my middle schooler, like, people don't listen to me, and neither do courts and hearing officers. And decisions are made by human beings who have differences of opinion. So can I give you a bright line test on that? No, I can't. But I can tell you that I think the more informed way of looking at an adverse effect is that it has to be something a little bit more significant. That's based on my reading of legislative history and what was said when the IDEA was reauthorized, and a whole bunch of geeky stuff that I get into when I try to answer these questions. But there are cases that go the other way, and there are cases that say, it doesn't say significant adversity. It doesn't say that. And so, but those cases are in your materials, and so I give you that with that caution. But if the child appears to have no issues at school, you can go to the next page of this, the next slide. This is good. The child has, you're looking at multiple different things, so the child, let's say the child is failing, that you're probably going to get there pretty quickly. They're below average, but they're still passing, that could be an indicator. Their achievement is below their ability level. That could, there are some cases in there in your materials. If the child appears to have no issues at school, and I'm talking about no issues beyond grades, the grades or attendance are fine, the behavior is fine, their social skills are fine, but the adverse effect is impacting something outside of school, well, that may not indicate an adverse effect on educational performance. I've had eligibility cases where the student holds it together all day in school. They are able to do their homework, but they are a hot mess when they're at home, and the parents they are a hot mess. They must be eligible for special education. They must be protected as a child with a disability. And the answer to those in some cases is no. If it's not having an adverse effect on their educational performance, they might have a diagnosis. They might be in a fetal position in their closet in the evening, but that is not a school-related educational disability. And so those are the things that teams have to wrestle with. Let's look at our next slide. So we talked about adverse effect. We talked about how adverse does it need to get. We talked about educational performance, that it is beyond those indicators of test scores and grades. And by the way, as an aside, I often hear, grades are subjective, and the teacher can be very subjective in terms of basing things on grades. So I throw that out there. So once you've decided that somebody does have a disabling condition, so we meet one of the criteria under all of those definitions of those disabling conditions, and then we say, and yes, that disabling condition creates an adverse effect on this broad scope of educational performance. We then move to, okay, we got two legs of the three-legged stool. What is the student's need for special education? So we're going to break that apart. The first thing is, what is special education at all? So that is specially designed instruction at no cost to the parent to meet those needs that you've just identified. Well, the definition, and I think it might be on this next slide, of specially designed instruction is adapting as appropriate the content, methodology or delivery of instruction. So if somebody doesn't need an adapted content, methodology, or delivery of instruction, they might need some regular ed supports. They don't need specially designed instruction, and that third leg of the three-legged stool is not met, and they're not eligible. So remember, when we talked about, should you be in the first 60 days testing out some interventions that may not be special ed. They may not be specially designed instruction. They may be adapting the content, methodology, or delivery instruction. If that's the case, then that would be special ed. But there are a whole host of differentiated instruction and different kinds of supports that don't fit in that category. And so that at the end of the 60 days, you've made the decision, yep, we've got the first leg of the three-legged stool. Yep, we've got the second leg of the three-legged stool. Now we're saying, does the student need specially designed instruction? You can look at your data at the end of 60 days and say, look at this response to these regular ed interventions. Look at the data that we have here. It shows that the student does not require specially designed instruction to address their disability-related needs or to participate in the general ed curriculum. And so at that point, your data is there to show the student doesn't meet the third leg of the three-legged stool, and therefore they are not a student with a disability. So those are how those two things can intersect and allow you to make a very data-based decision on whether the student needs specially designed instruction. Moving on to our next slide. So there are specific procedures, and I'm going to pause to see, Kim, Aaron, do we have any questions? Okay, I'm going to.
We do not. You're good.
Okay, so I'm going to be needing to leave in a little bit. So if there's additional questions, get them in now. But I will briefly mention that, specific learning disability, there are additional procedures that are required for engaging in the specific, looking at the learning disability. And as I mentioned, some specific requirements for doctors if they're making the related diagnoses. So, you can use the DSM in that. I'm not going to get into, and it would be, I don't have time to get into all of the specific procedures, but there are those references in the handout. Okay, next slide. All right, so we have made it to the end for the conversation about eligibility. I am going to turn it over to my colleague, Erin Heydrich, who I think is on. Let's make sure.
Can you hear me?
Oh, yes. Yay, Erin is here. Okay, so I'm going to turn it over to Erin. She's going to walk you through IEPs, and the same cautions that I gave you before are still applicable. Number one, Erin is an attorney who represents school districts, although she has Did
we lose Laura?
We did, and she has not gone in and out this whole time. And then right as she's introducing you.
Shoot. Okay. Well, I'll go ahead and introduce myself. My name is Erin Heydrich. As I think Laura was about to say, I'm an education attorney with Bricker Graydon. I've been an education attorney for 9 years, but the first 6.5 of those years were I spent representing parents and students in legal disputes with their school districts, including special ed disputes. So I have a little bit of perspective on both sides. Also prior to that, as those of you who've worked with me in the past know, and I see some familiar names on the list, I was a teacher before that. I was a high school English teacher for about 5 years. So I'm in the privileged position today of telling you how this should be done. But believe me when I say, like, I really truly do understand that so much of what I'm going to tell you today is so much easier said than done. This is a safe space. This is a judgment-free zone. As we go along, feel free to put your questions in the chat. I will answer them as we go. As a lawyer at Bricker Graydon, I practice almost exclusively in the student services area. I have a heavy focus on special ed. Today, for the remainder of our time, my focus is going to be on writing compliant IEPs. So we're going to go through, I may slip and refer to it as ODE, but I'm referring to the Ohio Department of Education and Workforce, ODU, DW, it's called different things. So I'm going to go through their PR07 IEP form, kind of step by step, and discuss best practices and legal compliance for each section. I'll provide some do's and don'ts based upon real IEPs that I have reviewed with names redacted to protect the innocent. So let's go to the next slide and start by talking about some IEP basics. So this is the easy stuff. You all know this, right? An IEP must be developed within 30 calendar, not school days of the school district's determination through an evaluation that a student requires special education. After developing the IEP, the parent must check one of the statements listed in section 15 of the IEP. Either they give consent, partial consent, or no consent for you to implement that IEP. The school district then issues a prior written notice in accordance with the parent selection. All right, I'm saying that I don't have internet connection. Are you all hearing me? Okay, I'm not sure where that is coming from. I'm gonna keep going. Yep. Okay. So you're going to issue a prior written notice confirming whatever the parents decide in terms of consent, and then you begin services if applicable, if the parent has consented to it. So from there, the IEP team must meet at least annually, but can meet more frequently to review the IEP. When does an IEP end? So it ends when one of these things happen. The child turns 22, the child receives a high school diploma, the parent revokes consent for services, or the IEP team finds that the child is no longer eligible for services. So until one of those things happen, you are going to continue to meet at least annually to review that IEP. Next slide. Thank you. All right, let's touch briefly on FAPE. This is our guiding light as we draft the IEP. So as you know, the IDEA does not guarantee any particular level of education or any particular educational outcome, but an IEP must be reasonably calculated to enable the child to make progress which is appropriate in light of that child's circumstances. Although we are going to go through the PR07 IEP form today, obviously the most important aspect of an IEP is not perfect compliance to the form. It is that it is designed to provide a FAPE to the student if it is implemented with fidelity. So if the substance of the IEP doesn't provide FAPE, it doesn't matter if we, check all the right boxes and put in the right dates, the IEP is not going to be compliant. One note here that will probably come up a few times today, may benefit from language is very common to see in IEP writing. But it's important to remember, as Laura talked about, the standard for FAPE under the IDEA is need. So the IEP team should include what the student requires for FAPE and only that. Now, if a member of the team suggests that the student may benefit from something, that is the beginning of a conversation. And that is going to end in a determination that the student does or does not need that thing, right? Now, that doesn't mean you as the district can't or shouldn't provide students with things they may benefit from that aren't needs. You can, and by all means do, just don't do it through the IEP, right? We want to limit the IEP to things that are needs, because when it goes in, it's really hard to take it out. And when it goes in, you subject it to all of the processes related to an IEP, right? All of the deadlines, all of the complaint rights that parents have, all of that becomes part of that very onerous IDEA process. So that's why it's really important to just limit the IEP to the things we are legally obligated to provide. All right, next slide. Laura just talked to you about ETR, so I'm not going to belabor this, but obviously the ETR is where you determine what the child needs for FAPE. And then the IEP is where you document how you're going to give it to them. So these two documents should be really closely connected to one another. Since the ETR only has to be done every 3 years, but IEPs have to be done every year, of course, there's going to be new data that you have to account for beyond just the ETR. But as needs identified on the ETR no longer apply as the years go by or as new needs are discovered, document that clearly in the IEP to show how the student is progressing. And obviously, if the student's needs appear to be changing really dramatically from year to year, or if the student seems to not be progressing at all, that's when it might be time to do an early evaluation. Slide. All right, now let's talk about the IEP itself. So we're going to go through all of the required components, and I'll talk about compliance pointers for each one. The IEP is a big document. That is no surprise to you, and I only have an hour, so I'm gonna, or do I have an hour and a half?
You have an hour and a half, I believe.
Okay. Okay.
Yeah, we're on
Erin-
here until 11:30, so if we can just leave a little bit of time for a couple questions as well.
Sure.
And Erin, I do have a question before you get started. Going back to you don't have to go back to the slide, but you had mentioned the ways that services would end was when a child turns 22.
Yes.
So we've had several districts reach out to us and ask if they're required to continue services until the end of the school year if they turn 22 in, let's say, February or November.
Yeah. No. But some districts do. Because
Does it need to be board policy?
you would want to check your board policy. Your board policy may say something about that. But like federal and state law would not require you to implement the IEP after age 22.
Thank you.
I see another question. Should we avoid using the phrase may benefit from? I think you should avoid it in an IEP. I think it's very common in ETRs, and that makes sense, right? ETRs are where we're like, let's figure out what is the whole range of things that this student may need. And then the IEP is the conversation about, okay, what do they actually need to provide FAPE, right? All of our students could benefit from a lot of things. But the standard for an IEP is what do they need to get FAPE? So I like to avoid using that language in an IEP because in an ETR it makes sense. In an IEP, that's really where we should stick to. This is what the team has decided FAPE, this child needs for FAPE. All right. Okay, so IEPs. Let's just a note real quick on the Department of Education's forms. Let these be your guide. The IDEA's procedural requirements are very complex, but ODE, was there another question? No, okay, thought I heard somebody. This form has been designed to help you comply with the IDEA's requirements. It is in this specific order for a reason. Every section is meant to flow from the one before it. So we can't decide the type, duration, location of a student's SDI before we've developed the goals, right? And we can't develop a goal until we know where the student is in terms of their present levels of performance. So everything flows from the next thing. So do it in order. And that has an additional benefit that you can use to your advantage, because sometimes we have parents show up in a meeting and they're like, I'm only here because I want to talk about this specific accommodation, right? It can give you a means to sort of redirect a parent who's so focused on one specific part, like specific accommodation, a placement, if they want to work out of order, right? Like, let's develop the conversation by following this form. One more note about this cover page. A lot of the information on this page becomes part of your EMIS reporting. So it is important to be accurate. The Department of Education guidance cautions us that we need to be especially attentive to the date of the meeting and the type of meeting held. Quick note about district of residence versus district of service, which is sort of hidden by the red, box, bubble, whatever that is here. District of residence is the school or district where the student's parents or guardians reside. The district of residence is always responsible for ensuring that FAPE is provided, right? So you are responsible for developing an IEP and implementing that, or ensuring that someone else implements it if the student doesn't attend your district. The district of service is the school district that is responsible for implementing those services. So if you are the district of residence, but you have a student who is being educated outside of your district, you as the district of residence still have the responsibility for initiating and conducting meetings for the purpose of developing, reviewing, revising the IEP, and maintaining communication with the district of service to ensure that that happens. Also note on the right side of this first page, there is a checklist to help ensure that you've completed all of the sections of the IEP. Again, the most important thing is that you actually complete all of those sections, rather than checking all of these boxes. But if you forget to check the boxes, then that can tend to serve as, if you get an OEC complaint and an investigator is looking at it, they might look at this first page and be like, this is a big red flag. They didn't complete the whole form, right? And it just might make them dig a little deeper. So just check the boxes as you go. Next slide. All right. Let's talk about dates. So you are going to be asked in this form to put the next IEP review date. That might be the date that the team has decided to reconvene to discuss ESY. Another example would be the date that the team is going to meet to determine like whether that maybe you're going to collect some progress monitoring data and review the IEP at that point. That might go there. But if none of those apply, then you would want that date to just be the annual IEP review date. Another thing I see sometimes is school districts will back up that date. Like they want to make sure they're compliant with that annual review date, which is great. And so they'll say, well, let's put the date 5 days earlier because then we'll know, we'll have a little cushion. It's a great thing to want to have cushion, but by moving up the end date on that document, you're essentially committing to the parent that you will review the IEP by that date. What I recommend is to put the next annual review date in this line, and then have some other outside scheduling system, some calendaring that like gives you a notification 3 weeks in advance or whatever to make sure you're meeting that deadline rather than cheating yourself out of the time that you have. Also a note here about prior written notice, right? So just like the word individualized is the most important word in an IEP, the word prior is the most important word in prior written notice in some ways. So the prior written notice has to be provided to parents before you are implementing the IEP. So not the next day, not simultaneously, but prior. A prior written notice can take a while to write. Some people are really good at like, they have a team member who can like write it in the meeting and give it to the parents right away, and that's great. But sometimes that's not possible. Sometimes you want legal to review it. So it's tough to write that on the same day as the meeting. So again, I recommend making an effort to set your IEP review a few days before, or I'm sorry, to set the IEP effective date a few days after the meeting, just to give you enough time to write a compliant prior written notice. So that's another reason why it's best practice not to wait until the day the IEP expires to have a meeting, because then you have no wiggle room. All right, next slide. Okay, excuse me. This is where you might put, this is the other information box. This is where you might put a student's medications, what languages they speak, if they have a behavior plan or a healthcare plan or a seizure plan that is outside of the IEP. Basically, this is for information that doesn't fit anywhere else in the IEP. One thing we'll talk about today is in an IEP, there should be a place for everything and everything should be in its place. So this is not the place to repeat information that you have stated elsewhere in the IEP. Previous Department of Education guidance has said if you have no information to include, you can write NA in this box so that it's understood that the section has been discussed by the IEP team, but you've decided there is no other information that's not included elsewhere in the IEP to include. This is one of the very few times that it's okay to put NA anywhere on the IEP form. So if there really is no other information that's not elsewhere in the IEP form, then you don't need to put anything in that box. Next slide.
Erin,
yes,
we have a couple questions before we move on about district of residence.
okay.
One is the question about district of residence for students in a community school. There's confusion about what goes in or goes on those spaces as far as district of residence and district of service for students who are in a community school.
Yeah, I don't represent a lot of community schools, but I believe that the community school is the district of residence. I need to look that up to confirm, which I can do. Did Laura take a break during her portion?
No, she did not.
Okay, well, maybe at like 10:20, could someone remind me? We could take a little break and then I can look that up just to confirm.
Okay, perfect. And then the other question is, if the district of service cannot provide the services, is the district of residence accountable to provide those services?
Yes, so if you are the district of residence, you are responsible for making sure the child receives a FAPE. So if you as the district of residence have determined that the child needs 30 minutes a week of OT and the district of service does not provide that, you as the district of residence would have to figure out another way to provide that. Contracting with someone or, talking to your ESC or something like that. Okay, let's see.
Kate, do you want to unmute and ask your question?
Yeah, thank you. I'm looking for just a little bit more detail. I've actually been talking to Laura about this as well, but we've had it come up a couple of times where some of the services as the district of service, we are unable to provide. In one situation, it's because we don't have a guardian for the student and they need an outside district placement. And we can't place the student without a guardian to sign off. So we're kind of at a loss, and we're wondering if the district of residence, if they have a placement that is available in their district, what are they responsible for that, or is that us that we need to figure that out?
That sounds like a pretty complex and thorny issue.
It is, definitely.
That I'm not sure I could answer without research. Yeah, I mean, if Laura's working on that with you, I would encourage you guys to keep digging. There may not be a clear-cut answer to that. I'm not sure that I could have a lot to add to that, in the time we have today. I'm sorry.
Okay.
Have to
Nope,
look.
I appreciate it. But like the general question though, I think you answered it. Like if for whatever reason, the district of service can't provide something, it is the responsibility of the DOR. Is that what I
Yeah.
understood there in general?
If the district of residence has determined the student needs XYZ for FAPE, and then the student is being served at a district of service that does not provide XYZ for FAPE, the district of residence will be held accountable for that, not the district of service. So that's why you as the district of residence need to make sure that those services are being provided in some way.
Okay, that mostly answers my question. I appreciate it.
Okay.
Thank you.
Okay. Would the district of residence answer change if you have a court documentation indicating district of residence is responsible regardless of whether the student attends? So I think this is referring to, there are some cases when a student is removed from their parents' custody. This is going way beyond the scope of IEPs, people, but I'll do my best. When a student is removed from their parents' custody, the court has to make a determination about which school district is financially responsible for that child's education. And generally speaking, although there is a very long statute that I do a lot of these cases, I have to reread the statute almost every single time. It's long and complex, but basically in most scenarios, the district that's going to be financially responsible for that kid is where the parents lived at the time the child was removed from their custody. So that is going to follow the child around. And so they may go over time, you know, they may be put in a lot of different placements and attend a lot of different schools, but as long as that court order is in effect, that initial district of residence is still going to be responsible for that student's financial expenses. That's what I think you're asking about. So if you have a court order saying that a district is financially responsible for that student, that district is going to remain financially responsible. Now, the actual district of residence still could change, right? Maybe the parent lives in Columbus when they're removed from their child's custody, and then the parent moves to Cincinnati. Well, now Cincinnati might be the district of residence responsible for FAPE. Columbus might be the district responsible for the expenses of the child, and maybe the student's attending school in Hamilton, right? So it can get complex very quickly. All right, if the parent utilizes the scholarship and sends their student to another location outside district of residence, it cannot. So no, if a parent uses a scholarship, then they have waived their right to FAPE from their district of residence. So the district of residence would not have to provide FAPE to a student who is on the John Peterson or Autism Scholarship. Keeping me on my toes. All right. Let's go back to our regularly scheduled programming. Amendments. So if during the IEP you need to amend, then this is where you document that, as well as in whatever section if you're adding an accommodation, you're going to add it to the accommodation section, and you're also going to note it here. There's a section here for participants to initial if any changes are made to the IEP by way of an amendment. Remember that amendments must be made in writing. If an amendment changes a placement, be sure to also complete the consent page. We'll talk about consent more a little bit later. Amendments also always trigger a prior written notice, so be sure to provide that. Important note, if you need to amend an IEP, this is one scenario where you don't necessarily have to meet to do it. If you as the district members of the IEP team and the parent agree that in writing that you don't need to meet, right? Maybe it's to correct an error, like everybody agreed the child was supposed to have a scribe and we just forgot to add it. If the parents are like, can you just add it without us having to have a meeting, and you and the district are like, yeah, that's fine, we don't need to meet, then that's okay. Again, document it in writing, but there might be times where everybody just is in agreement about what's needed and there's no sense in convening a whole meeting if you don't have to. Sorry, I have a question. Do you mean handwriting instead of typing? I'm not sure, Pam, what you're asking about, but if you want to give a little bit more information, I'll come back to that. Okay. Oh, you mean the consent to not have a meeting? An email documentation would be fine. It doesn't, for amendment, you said written. Oh, I just mean it has to be documented in the IEP. It doesn't need to be handwritten. It just, you need to include it in the IEP. If you make an amendment to change the least restrictive environment, but then within 2 to 3 days, this does not occur due to parent refusal, can you delete the boxes or do another amendment to the first amendment that never occurred? I probably wouldn't delete it. I would document it in a prior written notice, certainly, and then I would document it probably on the IEP that in this amendment box that, you know, this was proposed and parent declined to give consent. That's what I would probably do. Can a phone call suffice? And if the parent verbally agrees, can you sign their initials for them and say they agreed via phone? That's not my preference. Again, if that never got challenged, it'd probably be okay. My preference would be to have an email saying, an email exchange with the parent saying just send them an email for the call and say, hey, can you confirm we talked about this today, that we're not going to meet about exchange? That's what I would prefer. If like OEC was doing a complaint and I had to prove that it was changed without consent, that'd be my preference to have.
Yeah, and I'll just kind of pop in here because we work with OEC a lot. If they don't see parents' signatures, they will often mark those non-compliant. So because some of you work with different legal counsel, I would just suggest you reach out if you have a specific question like that, to reach out to what your legal counsel would say is defensible to you.
Yeah, that's a good point, Kim. I'm sure Laura touched on this at the beginning. We may not be your legal counsel, right? And so I will try to answer your general questions. But keep in mind that obviously I don't know all the facts of every situation you all are asking about. So if you have a question that is especially very fact specific questions, it's best to talk to your legal counsel. And if that's us, great, you can give me a call later. And if not, I would call your legal counsel and talk about what they would prefer that you do. We use the strike through feature, says Joshua, when removing something so it doesn't, yeah, I think that's probably fine. Okay, future planning. Let's move to the next slide. Thank you. So ODE guidance says that an IEP must include a statement that discusses the child's future. That's where this goes. The IEP team shall ensure that the family and the child's preferences and interests are an essential part of the planning process. The IEP team will document planning information on the IEP. So that's what ODU guidance says. Remember that the purpose of this section is really to document the family and the child's preferences for the child's future. So inclusion of the IEP team's preferences or the district's preferences is not a bad thing, but it's also not the whole point here. If you have a situation where parents can't or won't participate in a meeting, we don't want to leave this section blank. I would recommend trying to find another way to incorporate the parent or the student's preferences here, maybe through a questionnaire or an email or, you know, whatever you've got. But just remember the focus of this box is supposed to be where you document what the parent and the child want for the future. Next slide. All right, special instructional factors. So these checkboxes might seem overly simplistic. But it's important to remember that if the IEP team indicates any areas as yes, it must be addressed in the IEP. Critical one that we see get missed a lot is, does the child have behavior which impedes their learning or the learning of others? Often, or at least sometimes, we will see this box get checked as yes, and then there's no data in the ETR about behavior. There's no FBA, there's no goal about behavior. It's like, well, if they have these behaviors, we want to see those addressed somewhere. Sometimes in IEPs, we'll see comments about all different sorts of behaviors, self-harming behaviors, classroom disruption, work refusal, aggressive behavior, truancy. But then this box won't be checked, right? So that's sort of the opposite problem. Of course, the most important thing is that the need is getting served. But not form compliance is not the most important thing. The most important thing is that the need is being served. But let these boxes be a reminder to you. If you are checking yes on any of these boxes, that should be addressed in the IEP in some way. And if you don't have data from the ETR to address that need in the IEP, then that's a good trigger to go and collect that data. Next slide. All right, profile. So ODU guidance tells us explicitly that we are not to cut and paste all of the assessment data found in the ETR into the profile. We are only to include relevant academic or behavioral information that may have an impact on the student's academic and or functional performance. Keep in mind that the language must be understandable to parents and all team members if involved. So again, we're not a place for everything and everything in its place. So this isn't just where we like cut and paste everything. The ETR exists for a reason, and we don't just need to include the whole thing in here. But we want to include relevant academic or behavioral information that may have an impact that maybe we're not accounting for elsewhere. You should also include, if the student has a reading improvement monitoring plan, that should be included here. ODU guidance also recommends putting in the profile any needs identified in the ETR that are not addressed in the IEP. So remember, the ETR should logically connect to the IEP. Or should logically flow through. The two documents should be read kind of in tandem. So all educational needs and implication for progress monitoring that are identified in the ETR should be accounted for in the IEP, or we should explain why we're not doing that in the profile. So maybe there was a need identified in the ETR, but the student has made so much progress that we don't feel a need to include a goal or an accommodation or whatever related to that anymore. You can note that here. It may also be that the student has several needs and the team has decided to prioritize certain ones and work on other ones later. Again, this would be a good place to maybe document that. All right, next slide. I'm just checking. It looks like there's some questions maybe. When we get to the SLD category, Sarah, I'm very sorry. I am going to defer you. I'm going to direct you to your legal counsel on that one. That seems like a pretty fact-specific situation that I'm not sure I could touch on in our time today. Can you mark behavior needs if they have executive functioning needs that need to be addressed versus behavioral needs? I think the team would have to determine, and I don't know that there's a way to do it other than through an FBA. If you're seeing, if the team has determined, that's a team decision, right? Is this behavior coming from an executive functioning need that requires an executive functioning goal? Or is this coming from some other need that we need to address? I think that's going to be a team decision that you're going to have to make based upon the data in your ETR. If the team determines that a need no longer requires services, should that note remain in the profile of every IEP until the next reevaluate? I don't know if there's a hard and fast answer to that. I wouldn't necessarily, I probably would include it. Until we do another ETR. I probably would. Going back to evaluations, other categories. I might press pause on that one for a minute. I need to give that one a little bit more thought, which I can do on our break. Oh, and I just realized I've talked right through 10:20. So why don't we take a break? Let's take a pause. And then when we come back, I will try to give some more information about some of these questions that I wasn't able to answer before the break.
Do you want about a 10-minute break, Erin? Is that what you want? 5 minutes? What are you thinking?
Let's do 10 minutes. Sounds good.
Okay. So
All
we'll
right.
come back at 10:37.
Okay, thanks. That what is interesting to me about the IEP form is there is a field here for documenting that the team discussed the need for ESY, but there's nowhere specifically for listing what ESY services will be provided. So that there's no dispute. I'd recommend documenting if the team agrees that services are required, what you discussed and what you're going to provide. I would probably include that in the other information section, something like that. Okay, let's talk about post-secondary transition goals. Next slide. Okay, the first IEP in effect when the child turns 14 or younger if the IEP team decides, and annually thereafter must include goals based upon age-appropriate transition related to training, education, employment, and independent living skills if the data suggests a need for that. Note that the operating standards say that competitive integrated employment should be the first consideration for all students, including those with the most significant disabilities. At a minimum, your IEP must include at least one transition service that addresses each of the post-secondary goals that you identify here. There is an optional form that ODU provides, the OP6B, which you can use if you would like. The anticipated target date for graduation is entered at the end of section 5. That's based upon the specific needs of the student, not necessarily based on their age. The student must be invited to every IEP meeting where a transition is discussed, regardless of age and disability category. We need to notify the parent every time we intend to discuss transition, notify them that we've invited the student to the meeting. And if we're inviting outside representatives, like from outside agencies who may be assisting us with the transition conversation, we need to get consent from the parents, just related to having that person attend the meeting and discussing the student's information. Okay, let's move on to goal writing. This is probably the most important area of the IEP. It's also one of the most difficult areas to get right. Every goal, of course, starts with present levels of performance. This is going to be drawn directly from your ATR or any data that you've obtained since your ATR. Present levels of performance means what it says. It means present levels. So ODU says that our data should not be more than a year old. Remember, IEP is designed to flow logically, so teeing up solid present levels is going to help you write a compliant goal as you go along. ODU has given us some guidance on how to write present levels. They've said that the statement should be written in language understandable to all, including the parent. And there must be a direct relationship between the goal that you write and those present levels that you put above. So both of those things make sense. Keep in mind, of course, when you're writing any area of the IEP, that the IEP team includes the parent. Most parents are lay people when it comes to education. It should be obvious to a education lay person who looks at this document why the goals and objectives are written how they are, right? You should be able to draw a straight line between the two. ODU also says that present levels are not to be copied and pasted from the child's profile. This is supposed to indicate the child's current academic and functional levels compared to expected grade level standards in order to give us kind of a frame of reference of where they are. For example, if something about a student's disability is such that they're only capable of quite limited progress in a particular area, this would be a good place to document that. If you're looking at repeating a goal that was in a previous IEP, this is a good place to explain why. If there's not really a logical explanation for that, it could look to OEC like the IEP was not individualized or that the student is not making progress, not receiving FAPE. ODU guidance also tells us that if the student is currently receiving special education services, so if this is not an initial IEP, then we should include information about the child's progress toward their goals in their prior IEP. That must be included in the present levels of performance. So again, showing a clear line from ETR to IEP to progress report to next IEP. Having this clearly documented can help kind of stave off claims that your district is failing to provide FAPE, and that is causing the student's limited progress. Okay, so once we have our present levels in order, let's talk about how we're going to write the goal. I think maybe next slide. Thank you, Maya. So there are 3 elements of a measurable goal. The first is a clearly defined behavior, right? This is what the specific action we're going to ask the child to perform, and it should be based on one specific goal. ODU really does not like to see us blending skills like decoding and fluency in one goal. So each goal should also just have one verb, right? That's a good way to check and make sure we're not blending too many things here. The second element of a measurable annual goal is the condition under which the behavior is to be performed. If the condition is, we see this a lot, when given material, then it's important to specify the grade level, or whatever quantifier we're dealing with. So for example, when given a 4th grade reading passage. Excuse me. The last element of a measurable goal is the criteria that will be used to evaluate. So how will we know when the student is performing the behavior that we want? So this must include the level the student must demonstrate for mastery, such as 80%, and the number of times that they must demonstrate that, like 4 out of 5 trials. Next slide, please, Maya. So on this slide, we have an example of a compliant annual goal. It answers all of our key questions, right? Who, the student, will do what, make inferences by answering why, or what happens next questions. Note that the behavior we are measuring is making inferences. So that's our one verb, right? Making inferences. That's what we're measuring. Under what conditions? When given a sample of a 2nd grade reading material. To what level, degree or level, with 80% accuracy in 4 out of 5 trials. In what length of time by the end of the year? A note before we move on here, it's really important not to be vague when we're writing our goals. So a recent example that I saw was, given a real world problem, student will solve the problem using the correct process with 80% accuracy in 2 of 3 trials by the end of the IEP cycle. Here there's a lot of questions left open, right? What is a real world problem? What level of math would it involve? A real world math problem for a 2nd grader is probably really different than a real world math problem for a 12th grader. What is the correct process, right? When we say the student will use the correct process, what is the correct process? How will we know? So when you read through your goals, think, like, could a substitute come in and collect data? Like, would they know what to do if I showed them this? If it would not be clear what they would need to do, then the goal is probably too vague. So once we've written our goal, we're ready to move on to data collection. Maya, can you actually go back to slide 47? Yeah, perfect. Okay. So below our measurable annual goal box, we've got check boxes. So here is where we need to determine and identify the best way to monitor progress for that goal. Remember that if an observation box is checked here, there should also be a written record corresponding to that. So if we check the checklist box, we should be able to, I should be able to ask, or OEC should be able to ask, okay, show me the checklists that you have related to collecting data on this goal, or show me the work samples you collected, or whatever the rubrics, whatever it is, whatever box you check, there should be a corresponding record of that. Let's see, at the very bottom here, you're going to indicate the frequency of reporting progress to the child's parents. This is typically, it's required at least as often as children without disabilities receive report cards and interim reports. And that's usually the interval that people go with, although sometimes a student needs more frequent reporting, and this is where you would document that. ODU has a form, OP6A, which can be used for progress reports, or you can write your own, as long as it includes all of the elements used on the ODU form. Remember that while progress reporting to parents occurs at the end of each grading period, progress monitoring should occur throughout the grading period to guide instructional decisions. So, we shouldn't wait until the very last day of the reporting period to collect all of our progress monitoring data. And most people know that and don't do that. But all right, next, actually, can you skip 48, 49, and 50 and go to slide 51, Maya? There we go, SDI. I might pause here because I see some comments or questions. Oh, okay. I think these are just from Kim. Okay, perfect. Perfect. Okay, great. Thank you for that information, Kim. All right, let's talk about SDI. So the measurable annual objectives or measurable annual goals are they are what you're teaching the child, right? The goals we just wrote on the last page, that's what you're going to teach the child. SDI is how you're going to teach the child. And this is important, how those methods differ from what every other child in your district receives. SDI is not simply a list of accommodations, right? Remember the three-legged stool from Laura's Child Find presentation earlier. If the child does not require specially designed instruction, then they don't require an IEP. SDI should have a logical connection to whatever goals we identified on the last page. Again, the ETR is your friend here. Review the implications for instruction identified in the ETR to help you identify appropriate SDI. SDI means adapting as appropriate to the needs of an eligible child, the content, methodology, or delivery of instruction to address the unique needs of that child that result from their disability. Related services means other services that are required to assist the child to benefit from their special education. So that's kind of the differentiator there. Let's talk about some general tips for SDI and related services. First is to make sure you fill out all sections here. OEC specifically often watches for location, time, and frequency, making sure those boxes are like those questions are answered. According to ODU guidance, each element of SDI should be the responsibility of one provider and should be completed in one location. So it needs to be clear who is doing what, where, and for how long. If the same SDI is being serviced by more than one provider or is being provided in more than one location, like maybe the student is getting 30 minutes of reading in a reading resource room and 30 minutes of reading from somewhere else, something else. Those are two separate SDI rows. Second, use, please, for my benefit, if no one else's, or your lawyer's benefit, if no one else's, provider names, provider titles and not names. This is really helpful because people leave, and it's also really helpful for parents and people like me who may read the IEP and I don't know who Miss Smith or Mr. Jones are. Identifying like this is going to come from intervention specialist, this is going to come from occupational therapist, you know, whatever their title is really helpful. SDI can be provided by any intervention specialist or related service provider. Paraprofessionals and general ed teachers can reinforce skills that have been taught. They can implement accommodations and they can monitor progress. This means that the role of a paraprofessional and a general education teacher should be documented in the support for school personnel box at the bottom of this page, not in SDI boxes, because paraprofessionals and general education teachers cannot deliver SDI. Third kind of general tip for this page, the starting and ending dates, frequency, and the amount of time must be specified. ODU guidance tells us that the amount of time must reflect the need of the individual student and not the schedule or availability of staff. And you all know that. I'm not telling you anything new there. Okay, Maya, can you skip to slide 54, please? Thank you. All right, let's touch on assistive technology. You must provide these if they are required for FAPE, right? So if the child, that's a part of the evaluation, if you suspect the child may have a need for assistive technology, it's good to do an evaluation for that, and not just good, it's required. So do that. And on a case-by-case basis, in addition to providing the assistive technology in school, you may sometimes be required to provide it in the child's home or in other settings if the IEP team determines that the child needs access to that device in order to receive FAPE. Remember that need determines necessity in an IEP, right? Need determines necessity of an assistive technology device, not access to the device. What do I mean by this? I have very often had students whose parents are investing great sums of money in a device, and the district says, well, let us know when you buy that, and then we'll figure out how we can incorporate it at school. That might be okay if you as the district have determined that the device is not necessary to receive FAPE and you're going to incorporate the device into school as like a convenience or a courtesy. But if you as a team have decided that device is necessary to receive FAPE, then you, the school district, have to provide it and have to include it in the student's IEP. Okay, accommodations. Accommodations provide access to course content. They do not alter the scope or complexity of the information taught to the student. Again, here the ETR is going to be your friend in determining what accommodations you should consider. This is the biggest area of the IEP where I see what I call the no good deed goes unpunished problem. It is way easier to put something in an IEP than to take it out. One thing I see a lot here that causes problems is like daily parent communication, right? A lot of parents want that. I think it's rare that a child needs it to receive FAPE, but once you've put it in here, the parents will insist upon it, and they should, because you've put it in here and now they're entitled to it, right? So be really judicious and be really data-based when considering accommodations. Consult the ETR. Do not just add accommodations just to appease parents or to end the meeting, because that is where you can kind of paint yourself into a corner. All right, next slide. All right, so we discussed that accommodations provide access to content but don't modify content. Modifications, makes sense, are what modify the content. These change the amount or complexity of the instructional material taught. So maybe they're being taught the same curriculum as same age grade level peers, but with less complexity. Or maybe they are skipping selected portions of their homework, or given hints or clues, or they get a vocabulary sheet to like help them, or whatever it may be. All right, slide 57. Support for school personnel. So generally speaking, I advise that so this is a box for when, this is not for when an adult is providing services to a student directly, right? A school staff member is providing services to a student directly. This is generally where you have school staff providing support to school staff. So maybe a student has a hearing impairment and your district audiologist or whatever is going to consult with the teacher sometimes on like how to support that student. Reasonable minds can differ. I generally like to see if a student is going to have a one-to-one aid, that goes in this box, because that usually clarifies that the aid is working at the direction of the teacher, of the student's teacher. But people have different philosophies on that. That's just my take. Okay, next slide. Transportation. So your IEP team must determine 3 things. Does the child require special transportation? If the child has no need for special arrangements or accommodations for transportation, then transportation is not a related service, right? So does the child require special transportation? Does the child need transportation to and from services? And does the child need accommodations or modifications for transportation? Remember, our guiding light here is, are these things needed for FAPE because of the student's disability? All kids need to be transported to school because until they're 16, they don't drive, right? So they all need to be transported by someone. But the question here is, does this student need some sort of modification or service as a result of their disability in order to receive FAPE? Remember that if the child does require transportation as a related service, it must be provided at no cost to the parent, and that transportation becomes part of the child's FAPE. So it cannot be modified except by the IEP team. I sometimes get questions where it's like, well, we said they needed it as a related service, but maybe they really didn't, and now it's getting really expensive, and like, can we? No, right? So again, be careful. If a child needs it, you should put it in. You absolutely should, but just be judicious about what you put in, because once it's in there, only the IEP team can change it, and only the IEP team can only change it based upon a change in the child's need for FAPE, right? It can't be based on district convenience or impracticality. Okay, in what ways will the child have the opportunity to participate in non-academic or extracurricular activities with their non-disabled peers? That's what we're trying to answer in this box here. You know, a typical suggested kind of default language here is that the student has the opportunity to participate to the same extent as non-disabled students. The benefit of this language is that it covers the bases of all of those activities which require like tryouts or auditions. Because students with disabilities are required to sort of pass those hurdles just as non-disabled peers do, even if they may get accommodations doing so. It allows for applying conditions like GPA and discipline requirements, just as they would apply to non-disabled peers. So that's the typical language that I see. If the child needs certain accommodations in order to participate, then this is where we would document that. Okay, general factors. So this is again sort of a take a pause and think about, have we answered have we done everything we're supposed to do in this IEP? These boxes should not be checked no, generally, except, you know, potentially the third grade reading guarantee one. But as a practical matter, you know, sometimes I have been in IEP meetings where the parents insist upon a certain box checking no, like, you know, very often they might say, well, the IEP team didn't agree with me about my concerns for my child's education. And so I don't want to check that box yes, because I don't agree with what we decided. That's something to note in your prior written notice, right? If there was parent disagreement about something in the IEP. But if the team did truly discuss it and consider it, then you should check yes to that box. In section 10, the general factors section of the IEP, a third grade, you know, there's the third grade reading component. When no is selected, that consideration should be addressed in the student profile section. And or it might also be appropriate sometimes to put it in the present levels of performance section if that's relevant to a goal that you're writing. Also remember, last year, the Ohio General Assembly banned the use of a 3 queuing method to teach reading. So unless the child requires that as part of their IEP. So if the child does require that, make sure to add it to their IEP. All right, slide 61. Thank you. Okay. Least restrictive environment. This is often a difficult portion of the meeting, right? So if any setting other than the general ed classroom is listed for any of the specially designed instruction that the student is receiving, then the child does not receive all special education services with non-disabled peers. And a justification should be given in this section. If the child receives SDI, but they are all provided in the general education classroom, then they do receive all services with non-disabled peers. And that would include related services or anything that might be, you know, a pull out from their general ed classroom. Where I see errors here, you know, LRE is not an EMIS code. It's not a physical location necessarily. It's a description of what amount of access the student has to their peers. And an explanation of why the student needs to be separated from non-disabled peers, if at all. Education in the least restrictive environment, so education with their non-disabled peers is the default. It is a clearly established right. So this section is where the team justifies, based on the evidence it's gathered, why any more restrictive environment is justified in order to provide the student aid. Note that the presence of a disability alone is not a reason for a removal to a more restrictive location. So for example, due to the student's disability is not a sufficient justification, right? Give specific examples of why a separate setting is the best learning environment for the student to get FAPE. All right, next slide. Okay, this section addresses students who are provided accommodations on state and district level tests. and those who are taking the alternate assessment. For those taking the alternate assessment, the IEP team must justify the decision to provide that type of assessment and explain how they reached that conclusion. So for every student who's being considered for the alternate assessment, ODU has a form, a participation decision-making form, which must be completed, signed by the district rep, parent, gen ed teacher, intervention specialist, and attached to the IEP. So we just need to show our work, right? If we're going to determine that a student is to take the alternate assessment. The IEP team also needs to make a determination of the accommodations the student needs on district and statewide tests in this section. So the IDEA requires that students with disabilities be included in general and district-wide, state and district-wide assessment programs with appropriate accommodations as indicated on their IEPs. So accommodations on the IEP are broken down by subject because a student may require accommodations in one area and not another. District tests are any tests that the district administers to all students in a specified content or area or grade level. These are typically your kind of like off-the-shelf vendor produced tests like Terra Nova or iReady. Any state test is like a test provided by the Department of Education for use by all students in the state take, and that's like the OSTs. All right, next slide. Exemptions. So section 13 requires you to consider whether the student is exempt from the third grade reading guarantee. As you are aware, under recent changes to the third grade, not that recent, about a year ago, changes to the third grade reading guarantee, parents can unilaterally determine that their child will be promoted regardless of whether they pass the guarantee. If you select that the third grade reading guarantee exemption is applicable, you need to answer some questions. You need to discuss, does the child have a significant cognitive disability? Significant cognitive disability is not a disability category under the IDEA, but ODU guidance is that a child has a significant cognitive disability if they are eligible for the alternate assessment. ODU guidance also states that IEP teams should make this determination as close to the third quarter of the child's third grade year as possible. If the student, does have a significant cognitive disability, they will be exempt from all portions of their third grade reading guarantee. If a child does not have a significant cognitive disability, the IEP team can still decide to exempt the student from the guarantee. However, they would only be exempt from the retention provisions, not the other provisions. So they'd still have to take the test. They would still potentially be eligible for a RIMP, but they would not be subject to being retained. Again, parents can more or less unilaterally decide not to have their students retained now. ODU doesn't provide a lot of guidance on how to determine which students should be exempted, but if your team does decide to exempt a student, you should document your reasons for that here. The decision should be databased based upon present levels of performance, based upon any data you've collected in a RIMP or otherwise. So I would recommend, again, make a database decision, carefully document your reasons for that decision here, and in your prior written notice. That's kind of the best guidance that ODU has given us. Next slide. Okay. So section 14 is where we document meeting participation. This is different from the consent box, which we'll get to in a minute. The parent, of course, must be afforded the opportunity to participate in an IEP meeting. We as the school district are responsible for ensuring that meetings are scheduled early enough so that all parties have the opportunity to attend at a mutually agreed upon place and time. In order to ensure parent participation, the parent and school district can agree to participating by video conference or phone conferences, and that's pretty normal in our post-COVID world. If you are choosing to attend in an alternate method than in person, then you would document that as well. And this is documented at the top left-hand side of the page there. In addition to the parent, sorry, can you go back one, Maya? Thank you. The team, of course, must consist of a regular ed teacher if the student is participating in a regular ed environment, special ed teacher, a representative of the school district, an individual who could interpret instructional implications of evaluation results, any individuals the parents want to invite, and then the child if appropriate. So we would want to document all of that here. In some cases, a required member of the IEP team may be excused from attending the IEP meeting. Either they don't come at all or they have to leave early. That is okay as long as the district and the parent agree in writing prior to the meeting. And then the excused member must provide input into the written input into the development of the IEP. And they give that to the school district and the parent prior to the meeting. And then they are also required to sign the IEP form under people not in attendance who provided information and recommendations on the meeting participation form. So the bottom part there. ODU has created an optional form, a parent excusal form. You can use that form or you can change the form as long as it still contains all the components of that form, of the ODU form. The district is required to invite the student to attend if the student has reached the age of majority, if the team will be considering post-secondary transition. But you're encouraged to invite the student whenever, that makes sense, given their age, maturity, and interest. If the student is a minor, the parent has the right to decide if the student will or won't attend. As we just talked about, an individual who can interpret the instructional implications of evaluation results is a required member of the IEP team. This is often a school psych, but it depends on what evaluation results you're looking at. It could be an SLP, it could be an OT, it could be a PT, could be an intervention specialist. It really depends on the context. Again, this box documents participation, not consent. So let's move on to the consent portion of the IEP form. Next slide. Okay, this section is where the parents signed to indicate their consent, not just that they participated. So this is a good opportunity to discuss when parents' consent is required. It's required for initial evaluations or reevaluations, before initial implementation, for changes in placement, and for using public benefits or insurance to pay for special education and related services. Annual reviews that do not constitute a change in placement, consent is not required. Parents can note their disagreement, but you do not have to get their consent in order to implement the IEP. Now, if they withdraw their consent from providing services, then you would have to stop services. But if they just don't consent to this particular IEP, but don't withdraw consent for services altogether, then you can proceed with implementing the IEP. This is also where you document that you provided parents a copy of their procedural safeguards. There is also a place in this section to note that you have had the required transfer of rights conversation with the student and the parent. Beginning at least 1 year before the child reaches the age of majority, you must inform the child and the parent of their rights under the IDA that will transfer to the child upon reaching the age of majority. And so make sure to complete that section by the child's 17th birthday. Next slide. All right, so prior written notice, not a part of the IEP form itself, but this is really important, obviously. If there is a dispute that leads to an OEC investigation or a due process complaint, the PRO1 is going to be your most critical piece of evidence. You are going to explain what was agreed to and why, what was not agreed to and why, and also read it over and make sure a person who does not work in your building, who does not work in education, could understand what you are saying. So again, using job titles instead of names, or using both, right? I understand you might not want to just refer to people by their job title, but using both is really helpful here. Make sure it reads like that somebody who doesn't work in education, somebody who's maybe never been in your school building, can read it and understand what was agreed to. Next slide, please. Okay, I just talked a lot, and I see some questions. I'm gonna kind of wrap up these next couple of slides, and then I will turn to answering some more questions. So this was a lot to take in. I went really fast, but here are some quick and just kind of concise last minute tips about common mistakes that I see and how to avoid them. So The first one is ignoring needs identified in the ETR. So it's a really good idea to have your ETR in front of your team while developing your IEP. Maybe consider making a checklist of the needs identified in it and make sure that each one is addressed in the IEP in some way. So again, as we kind of talked about at the top, you're going to have a lot of stuff in the ETR that student may benefit from, student may benefit from, student may benefit from. It's really helpful to make a list of all those student may benefit froms or student requires and use that as a guide when you're talking about what is going to go in the IEP. And you can address it in the IEP in a few ways. It can be through a goal, it can be through a service, or it can be through an explanation in the profile about why it is not being addressed in the IEPs. And we talked about that, right? Maybe it's, well, we're working on, we want to have time to focus on these other goals as a baseline, and then we're going to move on to that one, or whatever it is. That's a good way to make sure we're not leaving anything out in that ETR. Timeline violations, obviously, monitoring your IEP and ETR timelines. These are theoretically the easiest part of the IEP to get right, but they're also in practice the thing that often goes wrong because you're juggling a lot of students and a lot of needs. Failing to make decisions based upon the individual needs of the student. Nothing in an IEP should be automatic or rote, right? Never should an IEP team member say, like, LRE, he gets services in X classroom, like all the other ED kids, right? Or we just don't have anybody trained to do that. Those are automatic red flags, right? That are probably going to trigger a complaint. So we're basing, and I truly do know how difficult that is. It might be the reality that you don't have anyone trained to do X, Y, Z. But if a student needs it, our answer should be, okay, we'll figure out how to get someone trained, or we'll contract with someone to provide that service. Failing to develop appropriate, objective, and measurable IEP goals, right? That's the primary purpose of an IEP. And remember, this is a team responsibility, including the parent, to work together to get that right. Failing to address all required IEP components, ESY, non-academic and extracurricular activities. This is where the checklist on that first page of the IEP is really your best friend. Go through that checklist, make sure you've talked about it all. If you forgot something, go back and do it. Inadequate data collection and reporting. Carefully think about, when you're writing the IEP, what method you're going to use for data collection, how frequently you're going to report it, and make sure everyone tasked with implementing the IEP follows that as written in the IEP. That's a lot of times what an OEC complaint comes down to is, like, did the student get what was written into their IEP? And you may have done it. You may have done it with perfect fidelity every single day. The student made beautiful progress on every goal. And if we don't have that written down somewhere, then we're probably not in compliance. And that's a real shame. So make sure we are keeping data. The other thing too is, a lot of times I'll see just maybe adequate progress written for data collection on a particular goal. We've set the standard in the goal, right? They're going to do it with 80% accuracy in 4 out of 5 trials. So we should be able to, the data should track what that goal says. Just saying adequate progress doesn't tell me. Does that mean they're getting it with 75% accuracy 3 out of 5 times? So make sure your data reflects the way the goal is written. All right, next slide. All right, failing to send progress reports at least as often as specified in the IEP, and at least as often as they're provided for regular education students. Again, it's another one that's like, it seems theoretically really simple to get right, but you guys are juggling a lot of needs, and sometimes it just falls through the cracks. Failing to ensure that all teachers and other appropriate district personnel have a copy of the IEP and follow it. This is a tough one. So, all of the school district personnel who are having contact with the student really should have a copy of their IEP. This can include coaches, administrators who handle that student's discipline, truancy officers, right? It's really easy to give those people a copy of the IEP. It is sometimes difficult to convince them that it's important to like read it and follow it. So, and I know I was a general education teacher and I often had like 20 kids in my classroom with IEPs and 504s. And I'm very confident I didn't implement every single one with fidelity 24/7. So, but this is another area where we tend to see complaints. All right, engaging in action that appears to be predetermination. So fully developing and finalizing an IEP prior to a team meeting, not being willing to consider the full range of placements or service options. These are things that probably don't just look like predetermination. They probably are predetermination. But remember that it's not predetermination for the school district members of an IEP team to have a meeting before the actual meeting to prepare. It is not predetermination to prepare a draft of the IEP meeting before the meeting. You may want to consider leaving like the LRE section blank, to make sure that the parents don't feel like you've come to them with telling them how it's going to be. If you make changes to that draft based upon parent input and team discussion, it's really like somebody mentioned redlining earlier, or strike throughs. It's really the best evidence sometimes in predetermination cases is where a district can say, here's the draft we sent to the parent, and here's what we ended up with our changes tracked, right? And that proves that when we were sitting in the IEP meeting, we did make changes based upon what the parents said. That is like basically bulletproof evidence against predetermination. So that's really helpful to have if you can. But remember what predetermination is not. Sometimes I get districts that are like, I can't talk to you about what I should propose in this meeting because that's predetermination. It's okay. You're allowed to talk about it. You're allowed to come into the meeting with a point of view. You just have to be open to also hearing what the parents say. And the more you can document that, the better. To that end, remember that IEPs are legally binding documents. They are akin to a contract. It's important to proofread. An occasional typo or spelling error here is not that big a deal, but sometimes they can inadvertently change the meaning of a sentence. Where it appears that language was copied and pasted from another student's documents into this student, where like you see another student's name get copied and pasted. Again, I don't reinvent the wheel, right? If you've got another kid that has like a very similar service or a very similar need or something, and you've written this beautiful something in their IEP and you want to copy and paste it, I do get it. And you shouldn't reinvent the wheel, but be really cautious about including other students' names because, parents hate it, as you probably know, and it's a really red flag for them, and it can lead to complaints. And it can imply that the IEP was not appropriately individualized. So proofreading is really important. Speaking of copying and pasting, remember our discussion about a place for everything and everything in its place. When you put information in more than one place in an IEP, and then you want to change some aspect of it, it's really difficult to remember to change that in every place you wrote it. And so that leads to a lot of copy paste errors and a lot of confusion when OEC comes calling and isn't clear what you intended with your IEP. A reminder, I've mentioned this already today, but IEPs, ETRs, PRO1s should be written in clear, specific language, should be understandable to a layperson, an educational layperson, which parents are usually. And it should be clear exactly what's being provided or measured. If you're referring to terms or concepts or people or locations in the building that a non-educator or person who doesn't work there might not understand, it's worth explaining it. The IEP should ideally be written such that if a student moves schools or if like you win the lottery and move to some beach town somewhere, good for you. Well, then you want them to be able to take the IEP to someone else and they should be able to implement it and knew what you meant when you wrote it, right? In an ideal world, that's how the IEP would read. So just taking a step back and considering what things are obvious to you that may not be obvious to parents or your lawyers or someone else in your building, or whoever comes in after you, if you leave the district, and whoever replaces you, that can be, that's really important. Okay, let's make sure I have touched on all these questions. In general factors, the way the final question is phrased, it appears to be asking us to mark if the child is on track, not on track for third grade reading. Guidance says otherwise, but the guidance doc language and language on the form doesn't match. I am not 100% sure what guidance you're referring to. I would need a minute to process that. I don't know. Kim, do you know what this is referring to?
I'm not sure which guidance document they're referring to either.
Okay.
Jamie, if you're still on here, if you could put that in the chat, which guidance document you're looking at,
That'd be great.
that would be helpful. Thanks.
Okay, if a student's schedule will be modified, but the student remains in the regular classroom, otherwise where all services are provided, where does this get reflected on the IEP? Student who needs to have a modified schedule to attend a specific counseling outpatient program, or a student whose medication is being adjusted and struggles to make it through the day, so the schedule is adjusted temporarily. I would maybe include that in the other information section, essentially the profile section. It sounds to me like this, the schedule is being changed in service to other needs that are probably documented in the IEP. But yeah, I don't know that there's any like hard and fast right or wrong place to document that. I think there's probably a lot of places you could document that. Yes. If a student is a minor, the parent can decide that the student should not attend, but you should still invite them if you are discussing transition. Parent revokes consent, then later once an IEP, does an evaluation need to be completed again? So yeah, my advice typically, I think this is supported by the operating standards, is that if a parent revokes consent and then wants an IEP, that the evaluation needs to be redone. We've had a situation last year in a school district where a parent revoked consent and then like 3 days later said they wanted an evaluation. So it can happen. Okay. Jamie, I just got the link for that guidance. I would need to take a look at that, and I'm happy to stay on for a couple of minutes and take a look at that and see if I can kind of make heads or tails of that. Are there other questions? I've got a few minutes left for questions. You guys ask such good questions.
So as Erin is looking at that, 'cause she said she could stay on a few more moments to look at that. First of all, we'd like to thank everyone for joining us. I did put a link for the survey in the chat. If you